Right. And so I'm gonna start with the what seems to me the meatiest, the most important, the most urgent issue, and there are so many of them. I hope I'm getting it right. Um, which is we talked about last week the question of whether or not we are drifting into or being steered into a constitutional crisis. And this is a term that is being used, I think, with greater and greater frequency in American politics. It particularly seems to be used on the part of liberals to talk about the presidencies of Donald Trump. Um, but I think it's worthwhile noting that it's also being often used by conservatives to talk about, I think, not just a particular president, but really the drift or the direction of constitutional law and interpretation, the growth of the executive branch of the administrative state, some of the post Watergate legislation as well. Um, and my concern is that we use the term with some accuracy, with some precision, that one of the dangers here is that if we over or misuse the term, it ends up just becoming another partisan football that gets lobbed around by each side when they don't like what the other side is doing, and that it gets diluted to the point where we may not be able to recognize a genuine constitutional crisis as it is arising. And so, in order to talk about this, I want to do some history today and some additional reflection. And I'm going to turn to history and conceptual clarification to try to understand what I'm referring to as the fragility and messiness of preserving constitutional democracy, preserving the rule of law, along with the Constitution as the highest order form of positive law, the form that allows us to restrict our ordinary processes of making and enforcing law in ways that secure both predictability. I know what the law is, and I know that I am secure when the law says I have these rights, when I have these entitlements, when I have these protections. I can not worry about that anymore. The law will actually be respected, and if it is violated, ultimately upheld. Alternatively, we have a situation in which the rule of law and the Constitution underpinning the rule of law are contested. And I want to refer to that as a constitutional impasse as opposed to a constitutional crisis. And it seems clear to me that we are in the middle of a constitutional impasse, if not yet a constitutional crisis. I want to preserve the term constitutional crisis for a more specific case where, in particular, the main branches of government who are collectively responsible for maintaining a regulative interpretation of the Constitution, hopefully because there's some constitutional consensus that allows them, despite their partisan differences, despite their principled disagreements, to say, at least we agree on, and sometimes this is called the rules of the game, but I think it's more than that. Yes, they're procedural constraints on how we contest elections, how we exercise power, and that's extremely important that politics not be a no holds barred contest. That's one of the goods that a constitutional consensus secures for us. It says, this is the game we're playing, these are the rules. Within those rules, we have a contest over the exercise of power, the prevalence of one or another political party, but we don't violate the rules. At least we're all playing the same game, and that constrains the way in which we exercise power, and it creates channels into which conflict and contest are structured and fed. And on the other hand, it gives us a certain security. The fact that the other party has won the election does not mean that they get to do whatever they want, that they have carte blanche, including to try to dismantle their opponents' organizations or even put them into jail, to attack the free press, etc. We are familiar, I think, with the, if you will, authoritarian playbook of trying to dismantle the rule of law to secure a one party or one individual domination of a political system. That's part of, I think, what a constitutional consensus secures for us. In addition to that, it's ordinary, everyday, personal liberty, right? And so here the idea that we settle some of our conflicts by constitutionalizing certain rights. And so there are certain rights that are protected only by ordinary law. Maybe we shouldn't even call those rights. Maybe it's just legal protections. But when we have those protections, we recognize they're secure so long as the law is in force. But perhaps there's an ongoing contest about exactly whether or not we should have those particular legal protections. When we constitutionalize a right, we give it a higher level of protection. We say it can't be taken away just by changing the law. The law that tries to take away constitutional rights is on its face unconstitutional, right? This is part of the issue with the effort to limit birthright citizenship to certain people when the Constitution doesn't seem to have any of those compunctions. Wait a sec, that's not just a legal matter, that's a constitutional matter that rises to a higher threshold of significance and security, and therefore we enshrine it in our Bill of Rights and really suggest to people you don't have to worry about the government even trying to do this unless there is a major change in the culture and the climate. Now, having said all of this is to point to some of the goods, some of the security, some of the freedom that comes with a constitution that preserves the rule of law, that contains a Bill of Rights, that takes certain issues, therefore, off the political agenda and gives us greater security that at least those goods will be protected from the ordinary machinations of partisan politics, from the shifting of transient majorities. But please note, constitutions do not interpret themselves. The law does not enforce itself. As opposed to that, we have to animate the Constitution and the law. We have to, through our actions, maintain an interpretation or have an orderly contest over the meaning of the Constitution or change the meaning of the Constitution, that this is part of the people's popular sovereignty over the Constitution, is our capacity to bring to bear new interpretations. Having said that, at that point, the Constitution becomes both fragile and messy. And in particular, I think we need to avoid and really scrutinize the supposition that just because it's in the Constitution, it is secure, right? A right is secure not just because it's on a piece of parchment in the Smithsonian, but because the major actors who control the government, who control the power to either respect or violate that right, agree on the meaning of that right, or if they don't agree entirely on the meaning, at least have a limited range of disagreement about it so that people can say, well, it may not extend to this case, or it may be controversial whether or not it entails this particular protection, but at least we know what the core meaning of the right is. And I have on the board here, I'll call it, first of all, a rogues gallery, right? And in saying that, I am suggesting maybe that Thomas Jefferson and Andrew Jackson and Abraham Lincoln and Franklin Delano Roosevelt and Richard Nixon and Donald Trump all share something in common, which is that they pushed the bounds of presidentially directed constitutional interpretation in order to accomplish what they wanted to accomplish as presidents. And when we're talking about Jefferson, of course, we're talking about his refusal to seat Judge Marbury to his seat, the origins of the famous Marbury v. Madison case. And the conclusion of the Supreme Court in that case is that the Supreme Court is the final interpreter of the meaning of the Constitution. And on the other hand, that Jefferson wasn't breaking the law, or that the law that Jefferson was breaking was an unconstitutional law, and so the Supreme Court didn't need to intervene to seat Marbury. And just to be clear, right, that's the beginning, maybe the first instance of watching our constitutional machinery in action in a moment where the president and Congress and the Supreme Court are not clear that they all understand the Constitution in the same way. And at that point, the Supreme Court asserts its authority but doesn't exercise it in this particular case. So Jefferson, I guess, concedes the supremacy of the Supreme Court, at least its interpretive authority over the Constitution, while being able to do what he wants to do. Andrew Jackson is a slightly more complicated case, right? He is told by the Supreme Court, actually the same Supreme Court justice who decided Marbury v. Madison, Marshall, in a troika of decisions about the way in which the United States needs or doesn't need to respect its treaties with indigenous Americans. The Supreme Court ultimately holds that the United States needs to, and Andrew Jackson basically disregards that holding and continues to use the American military to enforce his will of westward expansion and expropriation of native lands. Jackson probably didn't say the Supreme Court has made its case, now let it enforce it. Clearly, Stalin did say, right, I wonder how many battalions the Pope controls. And here we begin to get into the messiness and fragility, right? Jackson chose to disregard a Supreme Court decision and act in the way that he wanted to because he had the power to do so. That is getting very close to a constitutional crisis. Let me be a little bit more precise. I'm going to define a constitutional crisis as a period or an issue on which the different branches of government have differing interpretations of the Constitution, and each acts unilaterally on the basis of its interpretation, knowingly resisting or violating the understanding of the other branch. And so what I've called a constitutional consensus is no longer there. We have constitutional dissensus. And if I'm correct, that what sustains constitutional order is not the Constitution itself, but the shared interpretation of the Constitution when the branches of government are operating on independent and conflicting interpretations of the Constitution, and neither is willing to give or come to some kind of agreement or reconciliation with the other branch, then you have the beginning of a constitutional crisis, the beginning, that is, of the undermining of the consensus necessary to sustain constitutional order and the rule of law. And I think part of the reason Jackson got away with this without precipitating a broader crisis is because, frankly, this issue, respecting indigenous treaties or U.S. government in treaties with particular Native American tribes, is because it was peripheral both to the architecture of the Constitution and to the issues that most Americans cared about, or at least most Americans who were um, enfranchised and politically engaged. And so the fact that the victim were Native Americans, that they were marginal to both the constitutional and the political order of the time, should make us ashamed, right? Should make us regret this major stain of injustice in our history, but did not precipitate a constitutional crisis because it was not sufficiently central to the constitutional order. So, moving further along, we have Abraham Lincoln. And one of the things I think I would note is, right, that I guess, with the exception of Richard Nixon and Donald Trump, the presidents who have flirted with or precipitated constitutional crises or come close to at least constitutional impasses, to add a second term, which I'll say a little bit more about in a moment, are in our wallets, right? They're on our money. They're on Mount Rushmore. These are presidents who are regarded in our history books as among the most important in setting the direction of the country, in exemplifying presidential leadership. And here I will then just note in passing, especially when a president succeeds in prompting a constitutional impasse, and then the impasse is resolved in his favor. This is the case of FDR clearly. Then their flirting with constitutional crisis is actually a form of presidential leadership. It actually contributes to the evolution of the Constitution as a living document, where it is ultimately the sovereign people of the United States who have the authority to interpret or reinterpret the Constitution. The president claims the mantle to be a principle of the people, as do the justices of the Supreme Court, as do in good times the members of Congress. And then the question is, who has the more credible claim to represent the sovereignty of the people and their interpretive judgment on the meaning of the Constitution in a particular period? Well, FDR prevailed. Jackson prevailed. Jefferson prevailed. And by the way, so too did Lincoln. And here, Lincoln's constitutional sin is more direct, more obvious, less interpretive. He suspended habeas corpus, right? He violated one of the core provisions of the Constitution and the common law tradition. He did so advisedly. He tried to justify it by saying, look, the country's in the middle of a civil war, and if I don't take this extreme measure, there is a good likelihood that the South will win the war in order to preserve the Union and the constitutional structure at its heart. I'm going to have to sin against one of the provisions of the Constitution. A later Supreme Court justice famously proclaimed that the Constitution is not a suicide pact, and I think that is part of Lincoln's thinking. And I think many people who wrestle with constitutional morality and constitutional politics wonder whether Lincoln actually needed to suspend habeas corpus, or whether or not this was, in fact, an abuse of power by a president who was otherwise so important, not just in holding the Union together, but with the post Civil War constitutional amendments in bringing about an evolution of the Constitution from being a slave charter to being a post slave Constitution of genuine equal liberty, that we forgive Lincoln his constitutional sin. Moving next to FDR, and we've talked about this already recently, so I'll be brief here. As we know, FDR entered office in the middle of a crisis, right? But by the way, so too obviously did Lincoln. And he figured that he committed his administration to figuring out how to resolve the crisis of the Great Depression, the loss of confidence in banks, in markets, the loss of jobs, the loss of economic security, and the sense that the American economy had grown into a national and complex industrial economy, and therefore needed a more robust, agile, powerful national government to regulate it. And FDR started experimenting with the New Deal in order to accomplish precisely that. And what FDR did, of course, was to pass a bunch of legislation that the Supreme Court rather rapidly invalidated as unconstitutional. And when I say FDR passed the legislation in ways that we noted last week, right, there's a fundamental asymmetry between what Franklin Delano Roosevelt did and what Donald J. Trump is trying to do, which is that Roosevelt went through Congress, passed legislation, and then made it clear to the Supreme Court that two out of the three branches of government were claiming that they better represented the popular understanding of the Constitution, the interpretation of the Constitution held by a stable majority of the American people, reflected in the fact that they elected and then reelected and then reelected FDR and the New Deal Democrats in order to do precisely what they were claiming the constitutional authority to do. This is a constitutional impasse and not a constitutional crisis, because FDR and Congress didn't simply disregard the decisions of the Supreme Court. They didn't simply try, as Jackson did, to do what they wanted to do despite the adverse rulings of the court. As opposed to that, they waited, right? And eventually FDR threatened to pack the court. The court got out of the way. FDR now was able to secure a majority on the court and legislate with the New Deal Democrats in the way that he wanted. The difference, and now getting to the present moment, I won't talk very much about Richard Nixon other than to recognize very quickly that Nixon did not directly, through his actions as president, try to provoke a constitutional crisis. He was not, in the way that FDR was, or Jefferson maybe was, or Andrew Jackson maybe was, trying to provoke a new interpretation of the Constitution by acting on its basis before the court recognized it and challenging the court to ultimately extend the meaning of the Constitution for a new era. Richard Nixon got caught, right? Members of his administration got caught committing a crime, and he tried to cover it up. And in order to cover it up, when the Supreme Court said that the special counsel investigating the Watergate break-in should have access to Nixon's tapes, he tried to fire the special counsel, and his attorney general and his deputy attorney general resigned. Eventually, Bork enforced Nixon's order, and this then provoked a kind of constitutional crisis, because it appeared that the president of the United States was using executive power to directly either reverse or do an end run around a Supreme Court decision. And among the things that this led to was legislation eventually trying to make sure that abuse of power would be checked in the future. Congress siding with the Supreme Court against Richard Nixon, Barry Goldwater famously going to Richard Nixon and saying, if you don't resign, you will be the first president not only impeached but convicted, and you need to get out of the office, right? This then brings us to Donald Trump. And I think the parallels between Trump and Nixon are there, but quite a bit different. Obviously, we've had massive resignations in the Department of Justice over a order that many people felt was illegal, unconstitutional, and unethical to carry out, talking, of course, about the effort to dismiss corruption charges against the mayor of New York, Eric Adams, and the fact that 7 members of the Department of Justice resigned rather than carrying out those orders. This speaks to a transactionalism, right? Eric Adams is willing to let the city of New York be swept up in the deportation regime that Donald Trump is trying to put into place. And so since he'll play ball, we don't want to prosecute him, right? That is not in keeping with the rule of law. This is, I think, the beginnings of the signs that we may be edging further in the direction of a constitutional crisis. But having said that, I think the deep question here is whether or not Donald Trump and his administration will continue to abide by judicial decisions. And if they do, then I would argue that although Donald Trump and his administration are trying to change the constitutional consensus, they are not yet acting unilaterally on the basis of their interpretation of the Constitution and disregarding the interpretation that the courts have in place. That's the big, it seems to me, threshold of constitutional crisis. I don't think we're quite there yet, but I do think we are edging in that direction. So let me start in thinking more directly about the 21st century version of this. An argument, and it's an argument that is very popular in the new conservative circles. You see this, for instance, in the Claremont Review a lot. It's there in Project 2025. It's there in some of the legal and political theory of the new Trumpian Make America Great Again right. And it's an argument that Donald Trump is not, in fact, the origin or the impetus for a constitutional crisis, that instead Donald Trump is responding to a constitutional crisis that has been in place for a very long time, and that in fact traces back to Roosevelt and Nixon, and that he is in fact trying to resolve and remove that crisis. So what's the argument? And the argument starts with the post-New Deal expansion of the administrative state, or really the New Deal expansion of the administrative state, and the idea that this whole new, right, vast system of governmental agencies and regulations, which absolutely swelled in the middle of the 20th century through the end of the 20th century, is in fact a unconstitutional innovation, at least in the way in which it has been um, developed and interpreted by the Supreme Court and presidents through most of the last 100 years. And so the idea here is, look, this idea of a congressionally authorized administrative agency that is primarily run by civil servants, but located in the executive branch, and the chief or most important officials, which are appointed by the president, is nowhere authorized in the Constitution as such. The difficulty is, of course, we have an 18th century Constitution, and this is a 20th century innovation. I've referred to it as a kind of graft, trying to put a modern administrative state in a early modern constitutional structure. And the critics of this innovation say this is unconstitutional. And by the way, the current majority in the Supreme Court has some sympathy for this argument. It overturned, for instance, the Chevron doctrine recently, a doctrine that is pretty integral to the growth and the power of the administrative state, asserting greater judicial control and scrutiny over the administrative state. And another way of thinking about the difficulty from a constitutional perspective of the growth of the administrative state is that it not only removes issues from judicial scrutiny, it diminishes the power of the president to control his own branch of government, the executive branch. And the president should have final unilateral control over that branch of government, according to Article 2 and the way in which it's read by these critics. And this is the doctrine of the unitary executive. What the growth of the administrative state has done is to allow for congressional incursion on presidential authority. And Donald Trump, in asserting greater presidential power, including presidential power to violate the law, to fire the civil servants who have civil service protection, to fire the inspector generals who are supposed to have notice and cause when they're fired. What he's really doing is asserting his constitutional authority against unconstitutional constraints, right? And so Donald Trump is currently acting on a theory of the Constitution. His administration is implementing executive action on the basis of a theory of the Constitution that says he has the power to do this. And it was a mistake of FDR and the Warren Court, but also of every president since then and all the courts since then, to concede this power to Congress or to these administrative agencies. And it's time to undo that mistake and to return the Constitution to its correct meaning. And so that's argument number one for the idea that Donald Trump is doing basically what FDR did. He's trying to transform the Constitution and its interpretation through unilateral executive action. FDR was, by the way, working with Congress, so that's where the analogy falls apart. But having said that, this is not just brazen illegality and obvious unconstitutionality. This is an effort to remake the Constitution in accord with its more original and more plausible meaning, right? So that's the first plank in this argument. The second plank, I think, is similar, but it says in particular that what Congress did in the aftermath of Watergate, in making it illegal for the president to impound funds, to not distribute and spend funds that had been um, authorized for expenditure by Congress, and that Congress controlling the power of the purse, the executive being only an executive, he was bound to do what Congress told him to do. And now Congress passes an additional piece of law that says you are violating the law if you don't distribute those funds. Or, right, the so-called Administrative Procedure Act, which basically says the President of the United States has to follows certain administrative rules and procedures in hiring and firing and directing agencies and respecting their routines and the laws that generate those routines. These were efforts to say basically we were a little worried about the growth and the strength of the presidency, Congress saying that, and we want to at least exercise some supervising power. Given what Richard Nixon did, given the abuse of power, we're emboldened to do that, and we passed these laws. And again, I think that the constitutional theory of Donald Trump, of Make America Great Again, of Project 2025, is to say, look, first of all, it's not the case that those laws were ever constitutional. They're infringements. It's Congress that is overstepping its bounds in passing those laws, not Donald Trump who's overstepping his bounds in violating those laws. And secondly, and I think every bit as important, in the 21st century, we need a president who can operate with a great deal of power and speed, agility, because frankly, social conditions, cultural conditions demand that we have quick, responsive action. And frankly, the Congress is just incapable of that, probably structurally and institutionally, certainly in this period of heightened partisan polarization. Congress is incapable of doing what we need the federal government to do. And so the president has to claw back those powers that Congress tried to take from him illegitimately, unconstitutionally, and Donald Trump is doing it. And then we might ask, well, what are some of those conditions that require aggrandized executive power in the 21st century? And here I think, right, you could say, well, it's technology, it's economy, it's the military strength and cunning of our rivals. But I think, at least in these conservative circles, there's another argument being made, which is there is the erosion of the cultural cohesiveness and the foundation in shared values of the people of the United States of America. And frankly, the argument is that this swollen administrative state, right, has been taken over by liberal functionaries who are unwilling, because the law doesn't direct them to, because their values don't lead them to preserve the culture of the United States. And that culture is primarily a European Christian culture. And we want to have European Christians continue to play a privileged role in carrying and reproducing the culture of the United States. And we need a strong, bold president who does that, right? So the constitutional crisis that was precipitated by the growth of the administrative state and the post-Watergate laws is also giving rise to a cultural crisis that is causing the decline and disintegration of the United States, and it needs to be remedied first by restoring presidential power, and secondly by using it to um, counter cultural decline. So that's the argument. And I'm doing my best to give voice to it. I hope in a somewhat sympathetic way. It's obviously an argument I'm not particularly sympathetic with, either the constitutional argument or the cultural argument. Let me say for a minute then why I'm not sympathetic to it. And so the first thing I would say is I just think it's factually inaccurate to view the president of the United States as weakened in the 20th or 21st century by the expansion of the administrative state. And it's also factually inaccurate to say that the administrative state is on its face unconstitutional. It's factually inaccurate to say the president is weakened because I just think it's absolutely clear there's been a vast expansion of presidential power in the 20th and 21st centuries. In particular, military and intelligence power has become much more important, but it's also the case, and this is a more informal kind of power, that we have become more partisan, that our parties have become more sorted. They're not cross-cutting in terms of their ideologies. There aren't liberal Republicans or conservative Democrats anymore. And in terms of regional politics, in terms of racial politics, the parties have really drifted apart. And the president of the United States is de facto the head of his party while he is president, and that has given him great power over Congress, over the judiciary. It is diminishing the system of checks and balances. And you add to that, right, the growth of the importance of military and intelligence gathering for the operations of our government. You add to that the importance of the president as the initiator of economic policy. I think it's just clear that the president of the United States, if anything, has expanded dramatically in the direction of having an imperial presidency. So that's argument number one. Argument number two, in parentheses under point number one, is that what has driven the transformation of the culture in the direction of being more diverse, less traditional, more open to elective decisions about what religion we're going to subscribe to, what gender we're going to perform. And by the way, with this, the racial diversification, the transformation of gender roles, what has driven all of this is not the weakening of the president, but the gradual evolution of both the demographics and the culture of the United States in the direction of a multiracial, post-traditional democracy. This is not something that can either be blamed on policy, and in particular, the supposed weakening of the presidency, or on, or remedied by a policy. Excuse me for 1 second. The idea, right, that we can legislate or use executive power back to right the 1950s so-called Make America Great Again policy. It just doesn't, I think, pass the laugh test as an actual approach to bringing about cultural reform. Cultural reform is very difficult to impossible to legislate. And certainly, this kind of bullying use of executive power is not going to change the fertility rate of white Americans and Latino Americans, right? And so the forces driving the diversification of the United States are not going to be responsive to increased executive power. It's not going to make people go back to church or, frankly, stop having abortions. It's not going to make people conform to heterosexual standards of gender identity. This is not the way the law works. It can't coerce cultural tradition if people do not voluntarily want to sustain traditional culture. So, moving to the second point, it seems to me, if I've got it right, that the presidency has actually become more powerful, and the restraints, such as they are contained in post Watergate legislation or the institutionalization via law of some independence on the part of executive agencies, such that they're not just the plaything of the president, that this growth in presidential power is ultimately rooted, in part at least, in congressional dysfunction. And we've talked about this before. It's been a long time, but the political scientist Frances Lee at Princeton has, I think, some very important studies of when Congress works. And her finding is that Congress tends to work during periods of partisan supremacy or hegemony. One party really is predominant, has a supermajority in both houses of Congress. This was the Republicans from the post Civil War period through the late 1920s, and it's the Democrats from the 1930s to the 1980s. These are periods when Congress is strong because Congress has partisan supermajorities capable of legislating, capable of working with presidents, but also checking presidents if the president is abusing his power or if Congress disagrees with the president's legislative agenda. But beginning in the 1980s, Frances Lee shows, and I think it's absolutely clear, we lost one party hegemony. We've moved into a period of partisan parity. And I think it's just so striking, both in terms of the numbers in Congress right now, right? The smallest majority in the House of Representatives since there have been 50 states, the very slender majority in the Senate, the fact that a number of swing states that voted for Trump also voted for Democratic senators, this sense that neither party really has the enthusiastic support of the supermajority of Americans. And I want to say two things about that in the context of today's talk. One of them is that makes Congress weak, right? And so that tends to cause power to drift into the judiciary or the presidency, assuming not that this is a zero-sum game per se, but that the weakening of one institution so that it cannot play its function in the constitutional structure of the United States. Congress is having a hard time legislating. Look, it's having a hard time even passing budgets and continuing resolutions. That opens the door for the other branches to assume more power. In addition to that, and I think highly relevant in the current moment, is if we have two parties, neither of which attracts a stable supermajority, and they start to drift apart, not just on policy issues, they become more culturally polarized. They really begin to inspire in the people who identify with them deep mistrust and hostility of the other party. And then they start to operate on the basis of incompatible and conflicting interpretations of the Constitution. Well, we go back to where we started. The Constitution does not interpret itself. When we succeed in using the Constitution as the bedrock of the rule of law in the United States, it is because we have at least a modest constitutional consensus, some shared understanding of how to interpret the Constitution, what its key provisions mean, what rights it protects, what is taken off of the ordinary political agenda by the Constitution. And in an era of partisan polarization, if the partisan divide includes a divide over the interpretation of the Constitution, constitutional consensus is likely to break down. And it seems to me that that is what we are beginning to reckon with. I don't think we're all the way there yet, but we are drifting in the direction of a situation where a large portion of the population is going to say, that's not my president, and potentially that's not my court, and potentially that's not our Constitution. And that's a very dangerous extension of the logic of partisan competition from ordinary electoral politics. Yeah, so we end up with a president we really don't like. That's the risk of democracy. We got to do better next time. But if we end up with a sense that our Constitution is no longer being enforced, that we no longer recognize the way in which the document is being interpreted as an expression of our core values or our sovereignty, we're in a deeper kind of crisis. So I'll conclude today by saying that if a constitutional crisis is looming, it's been preceded by long-term constitutional fragility and dysfunction. And I wanted to read to you a little bit of Madison's Federalist number 10. I don't think I will have the time to do it today. It's a long passage, so we'll return to it at another time. But I would point out that Madison, who in many ways was integral to the structure of the Constitution, many of its features, but especially the authoritative interpretation of the Constitution as a result of his very large role in American politics, the author of some of the most influential Federalist papers that made the case for the ratification of the Constitution, then the chief author while in Congress of the Bill of Rights, then the architect of one of the first political parties in the United States, along with Thomas Jefferson, the so-called Democratic Republican Party, and then the President of the United States. And Madison says very clearly that it's impossible to eliminate diversity, faction, party, conflict from American politics, from the politics of any country. And that as opposed to that, what we need to do is to harness it institutionally so that it becomes constructive as opposed to destructive. So we're going to disagree, and our disagreements, our rivalry, our conflicts around interest, principle, ideas can be productive and healthy if we have institutions that allow us to, on the one hand, represent our differences, and on the other hand, force us to compromise, to learn from each other, to talk to each other. And by the way, at the heart of the institutional structure that requires us to do this is Congress, because Congress in its design represents those differences, right? It's not a single individual. It's not a very small number of individuals appointed for life. It's an institution that is repopulated on a regular basis according to the current ideas and interests of the people of the United States. And so it plays a critical role. That's why it's defined in Article 1. Article 1 concerns the powers and structure of Congress. And that's why Congress is given the power to make laws and the power to control the expenditure of the federal government, the power of the purse. It's kind of the heart of American government. If Congress has been undermined by partisan polarization, by the growth of the executive, if its 18th century and 19th century and 20th century procedures paralyze it in the 21st century, then I think we have an alternative understanding of the fragility of our constitutional structure as rooted in what happens when we're polarized and have rough parity between the two parties, and Congress is therefore incapable of acting. This is a very different understanding, which suggests what we need to do is identify the roots of the problem with Congress and address them, as opposed to trying to augment the power of the president to compensate for the fragility and dysfunction in Congress. So, very quickly, what are those roots? Partisan polarization itself, I think, is the critical origin of congressional dysfunction. But in addition to that, growing inequality, right? And this is a social problem, not just a political problem. Large portions of the American people have been rendered precarious by the current economy. But we add to that, by the way, that American politics has become extraordinarily expensive, a multi-billion-dollar affair conducting elections. And when you couple inequality with very expensive politics, you end up with unresponsive politicians, politicians who respond, that is to say, only to the people who fund their campaigns and not to ordinary Americans' concerns. And this then leads to the perception that we lack agency in the 21st century. We lack the political capacity to make our needs and interests felt and translated into laws that actually address our urgent concerns. And so the idea, I think Donald Trump is responding to, and then also certainly fomenting as well, is that, well, if Congress is not going to do it, then the president needs to step in. He will restore agency for the American people who are desperately in need of strong leadership. We add to that increased complexity and growing frustration with the incapacity of government to meet urgent needs, the decline of traditional culture, and we are in one of those moments where, right, Congress is really going to struggle to act. The appetite for a strongman leader is going to really be prevalent in our politics. The worry is that this is not the right conditions for us to successfully navigate a constitutional impasse. If Congress can't stand up for its interpretation, if it's unwilling to, you probably have seen, I've got it on the slides, but I didn't get to it. But right, Tom Tillis's wonderfully revealing statement, right, that Elon Musk and his quote, Department of Governmental Efficiency run afoul of the Constitution in the strictest sense. I'm not quoting Tillis, but nobody should bellyache about that. It's not uncommon for presidents to flex a little bit on where they can spend and where they can stop spending. Well, I'm sorry, Mr. Tillis, but I think we probably should bellyache when the Constitution is being violated by the president. And by the way, your role as a senator is to stand up to the president when he's violating laws that empower your institution or a constitutional structure on which your power rests. We haven't had a chance to talk about the resignation of 8 members, I guess it's 7 members right now, of the Department of Justice over the effort of the administration to have corruption charges against Eric Adams dismissed. But again, I want to be as clear about this as possible. Let me quote for a moment Hagen Scotton, who's the acting assistant U.S. attorney for the Southern District of New York. I can get the slide on the board because I am actually quoting from something I've got on a slide. Give me a moment. And what he says, I have Tom Homan, the Homeland Security, I'm sorry, the border czar, saying, look, we cut a deal with Eric Adams, and he's got to deliver now. And this is directly contradicting what the Justice Department is saying. They're saying they just concluded that they don't want to bring the case. And so this is what Hagen Scotton says as he tenors his letter of resignation. No system of ordered liberty can allow the government to use the carrot of dismissing charges or the stick of threatening to bring them again to induce an elected official to support its policy objectives. There is a tradition in public service of resigning in a last-ditch effort to head off a serious mistake. Any assistant U.S. attorney would know that our laws and traditions do not allow using the prosecutorial power to influence other citizens, much less elected officials, in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion to dismiss this case, but it was never going to be me. Please consider this my resignation. And here again, I think we get at this core idea that for the rule of law to be upheld, we need to have people in positions of power who say what Hagen Scotton say, right? I'm going to follow the law and not the whim or will of the president. He may be the president, but he too is bound by the law. And clearly, this administration is starting to root out these people in key positions so that it is not encumbered by their principled conduct. This is not yet a constitutional consensus, but it sure, constitutional crisis, but it sure looks like we are drifting in that direction rather quickly. Let me stop there. I know I went a little bit over. Happy to take your questions, comments, thoughts. Who wants to start us out? Go ahead, Flossie. Are you unmuted already? Yes, you are. Go ahead.
I'm afraid we are losing our language. We have to have a common language to understand what's happening to us. And we need teachers who know how to interpret what is happening to us. And it is at this moment that we are losing our teachers and our language. I'm not afraid of having many languages, but when it comes to how we live and how we live with one another, we need a common tongue, even as we respect different ways of speaking. There has to be a common tongue that says this is what we are and what we are not.
What we stand for and how we limit ourselves. And so I like the way you've put it, Flossie, a common language. I use the somewhat more specific term, a constitutional consensus, and I focused primarily on the main actors in the federal government, the judiciary, the Congress, the president. But I think you're absolutely right that ultimately what keeps Congress and president uh, in accord with a shared language, a shared understanding of the meaning, the significance, the limits that the Constitution and the idea of the rule of law impose on us is the people. And the people have to have, and here I'll just maybe be a little bit more sociological, anthropological, a shared civic and political culture, right? That says we don't do that. We have certain forms of civility and respect that mean that we treat each other in certain ways and don't treat each other in certain ways. We have certain shared commitments that mean we don't just use the threat of prosecution when somebody has credibly been alleged to and in fact indicted for violating the law. We don't just use that as a bargaining chip to pass policies or administer policies we like. We care more about the rule of law. And so yes, the broader culture is being eroded. You point to teachers. I'm also going to point to the media system, right? And so I've pointed a little bit to political parties and how uh, segregated, segmented, and mutually mistrustful and hostile our parties are. And then I think we need to add to that, we're watching mutually incompatible media. And the result is that we have very different understandings of the world, right? The anxiety about trans athletes in the NCAA turns out there may be 10 trans athletes out of hundreds of thousands competing in the United States today. This is not a crisis, right? But if you turn on conservative media, you will not get that information and you will be led to believe that something deeply unfair and perverse is happening in college athletics right now. David, go ahead.
Yeah, I was just going to say, can you hear me? Am I unmuted?
You're fine.
Good.
Yep.
Um, uh, I think about Trump and I think about his history as a TV star and a deal maker. And it seems to me that if you look at what he's doing now, and this thing with Adams is a perfect example. He's cutting a bargain. He's making a deal. He's being Donald Trump. That's how he gets business done. And an interesting thing has happened if you think about the Congress. Uh, I remember back when people like Tip O'Neill were in charge of the Congress, legislation was all about backdoor deal making. And what Republicans and Democrats had to do was to set their principles aside, cut a deal where they could get a bridge if they looked the other way on their principle of, democracy or whatever it was. And we got laws passed. Now Congress is not transactional; it's ideological, and the deal making has transferred over to the executive, and that's where deals get cut, and that's where I guess things happen because you got to sometimes cut deals in order to uh, move things along and the like. So I just find there's a certain kind of irony in the shift to ideology versus uh, self-interest as the motivation for the executive versus the legislative branch.
So I'm gonna run with some of those themes, push back on some of those themes, and
Sure.
so I'm gonna start on with the idea that look, part of what Congress does is bargaining. Yeah, and so you can call it deal making, you can call it compromise, right? But the idea that you the way you get complex legislation passed is by trying to build as broad a constituency as possible for it, and to build a broad constituency, you have to make certain concessions or cater to certain interests that may not be exactly akin to what you're trying to get done, but they don't undermine it, right? And I would just point out to you very quickly, there was a fair bit of that in the last Congress, right? So whether it's what we need to do to bring Joe Manchin along or Kristen Sinema along, that stuff was fairly obvious. But I think there was a lot of stuff in the, for instance, infrastructure and inflation reduction bills that were there to bring in a senator, a congressperson, a lobbyist, and that's not, I think, extinct. I think that's still occurring in Congress. But having said that, I also want to then pay attention to things that aren't legitimately subject to bargaining, right? One of them would be, can you violate the law and do it with impunity if you have the right thing that powerful people want to trade in for your get out of jail free card, right? And that seems to be what's going on with Adams, right? That the deportation czar wants access to the infrastructure, the jails, the prisons of the largest city in America, the one that has perhaps the highest concentration of unauthorized migrants in its midst. And so if the price of Adam's freedom or the price of getting access to those jails is giving Adams his freedom, so be it. And at some point, I think we have to have a distinction between issues on which it's legitimate to bargain and issues on which it is in fact not legitimate, because to start bargaining there threatens the rule of law, violates the law, threatens the constitutional structure. And here I completely agree with you. Donald Trump has never thought that it was important to obey the law, doesn't seem to have any real appreciation for the institution of the rule of law and why it might be valuable as opposed to merely a hindrance on people like him, powerful wealth creators doing what they want to do. And then let's just notice for a second, I think, Donald Trump is kind of an old school bully and businessman who just wants to grease the wheel and get the regulator out of his way, that he's currently paired with Elon Musk, who's a very different kind of entrepreneur, who's a right Silicon Valley entrepreneur, but there's a Silicon Valley version of this ideology as well. Move fast, break things, be able to figure out what works in part by figuring out what doesn't work, in part by just disrupting routines, and that Donald Trump has given Elon Musk incredible power over the federal government. And frankly, the federal government is not Twitter, right? When Twitter breaks down, users are unhappy and our public sphere is flooded with disinformation. It's not great, but it's not the same thing as when our drug approval process or our medical research process breaks down, or our highway safety or our food safety, or heaven forbid, our airline safety breaks down. It's not the same, frankly, as when access to our national parks. I don't know if you've seen the recent stuff about layoffs in the Forestry Service and failure to rehire the seasonal rangers in Yosemite. They're just that it looks like a lot of stuff that we rely on the government to do is in danger because of the different kinds of transactionalism of this administration. And it's not just, you know, routine congressional bargaining. There's a legitimate place for that. There's corruption in that. The risk of corruption accompanies the legitimate role of bargaining. But this is a different kind, a different order of
Sure.
transactionalism.
Donald Trump's deal making knows no legal, moral, or ethical bounds. Uh, there's and you could regard the deal making of Congress in epochs past as more benign than malevolent.
Yeah, I mean, I think we have to be careful, right? You remember that FDR, in order to get the New Deal passed, basically allowed African Americans to be excluded from the provision of
True.
almost all of the goods. Some of it is not so benign, right? But having said that, this is, you know, the messy process via which legislation is made, like making sausages, it's unsavory. But having said that, I think it's one thing to talk about routine horse trading in Congress. It's another thing to talk about undermining the rule of law. And it worries me we're moving in the direction of the second.
Sure.
Anybody else for today? All right. You guys be well. We'll keep going. There's a lot more to talk about this. For instance, who are the people in the federal judiciary? If Congress has relinquished its role, it really is going to fall to the judiciary to check the Trump administration's effort to make right executive power incredibly expansive and unilaterally exercised. And by the way, that means we got to pay attention to who the judiciary is, how they got there, what their agenda is. That's something I want to speak with you about in coming weeks. Be well, everyone. Good being with you as always. Look forward to seeing you next week. Bye, guys. Thank you.
Thank you, David.
My pleasure as always. Thank you, guys. Bye bye.